Hi, I'm Geneva Jones-Taylor, partner with the law firm of Powell, Youngblood & Taylor. I'm the firm's special education and disability rights law practice group leader, as well as a managing partner of the Houston office. In July 2020, 2 attorneys out of New York filed litigation regarding COVID and special education students, naming every state education agency throughout the country, as well as nearly every public school. The crux of their allegation is whether the school districts violated the students with disabilities' rights to receive a free and appropriate public education in the public school setting based on those closures. They cited numerous laws, including the IDEA, Section 504 of the Rehabilitation Act, the American with Disabilities Act, and other civil rights laws. Now, we're going to explore those, but I want you to stay with me. I'm going to use some legal jargon, but I'm going to explain it to you, and it's all going to make sense in the end. So here was where we start. They filed under the IDEA. Now, the IDEA is the Individuals with Disabilities in Education Act, and what that law says is that school districts must provide education and related services to students with disabilities who meet the eligibility criteria. In order to file under the IDEA, they must have exhausted their administrative remedies. Now, there are more than 200 petitioners and plaintiffs in this actual litigation, and therefore it is highly unlikely that each of those individuals has already exhausted their administrative remedies to allow them to get into federal court. They also filed under Section 504 of the Rehabilitation Act of 1973. Now, Section 504 is an anti-discrimination law, and it essentially says that you cannot discriminate against individuals with disabilities based on their disability. Section 504 applies to schools because these schools are receiving federal financial assistance. Section 504 only applies to individuals and places that are receiving federal financial assistance for discrimination purposes. They also filed under the American with Disabilities Act. American Disabilities Act came about in 1990, and what that law did is it took the provisions of Section 504 of the Rehabilitation Act, which says if you receive federal financial assistance, you can't discriminate against people with disabilities, and applied it to the private sector. The private sector being transportation, residents, things of that nature, and employers over a certain number of people. The ADA is for the private sector, so filing under the ADA seems irrelevant at this point because it doesn't apply to our public schools. Now, here's where the hypocrisy comes in. You ready? They're asking as one of their sources of relief for vouchers. They are asking to take public money, take your taxpayer dollars, and then put them towards a private school that is not required to adhere to the IDEA, a private school that is not required to adhere to Section 504 of the Rehabilitation Act, a private school that may not even meet the definitions of disability under the ADA or other civil rights laws. So you're suing under these federal laws in order to take money out of public schools to put it into a private school that doesn't even have to adhere to the laws for which you sued for in the first place. Hypocrisy. Now, if you're concerned about students with disabilities, it's important to understand that students with disabilities have numerous options to access their education in the public school environment, including non-public schools. The IDEA allows for school districts and educational agencies, which it often refers to as LEAs, to contract with certain private schools, provided that that private school is going to adhere to the rules and the laws and the anti-discrimination statutes that the public schools are adhering to. So if a school district or a public education agency, like the Texas Education Agency, contracts with a private school, for which they do, that public school is required through that contractual arrangement to provide services under the IDEA, to make sure that students are not being discriminated against Section 504 of the Rehabilitation Act, as well as other state and federal laws against discrimination. So there is things in place if a school district for some reason cannot provide within the public school system for a student with disabilities. There are options. The federal government has already established these way back when the IDEA was established. Non-public schools are a viable option. Taking money out of the taxpayer dollars and giving it to someone so they can put their child into a private school is an illegal gift of public funds. We cannot just give taxpayers' dollars away. We have all the resources necessary to provide for students in the public school environment, which includes an option for non-public schools if it is necessary. The reason that is because we're fighting to ensure the rights of children throughout the country. That is why non-public schools are part of the public school system, because there are some children who cannot receive their education. Now, when we talk about Section 504 and we talk about these school closures, understand that all of the schools were closed. All of the children were transitioned from the in-classroom brick and mortar system into a distance or remote learning model. And school districts throughout the country, especially here in the state of Texas, worked diligently to ensure that the students with disabilities were receiving access to their education in that remote learning environment. Whether it was through virtual instruction, whether it was someone coming to their home when they were allowed to, based on the local ordinances regarding the pandemic, whether it was having phone calls, whether it was books and paper, whatever it took, they were providing for those students. And where they couldn't, they received notice that we would be compensating the children for any losses that occurred, which is allowed under the law and which is the recommendations of the U.S. Department of Education as well as Texas Education Agency. For the most part, schools haven't even resumed yet in order for us to be able to provide compensatory education for those students. This is nothing more than a ploy to force a conversation and to force the public's hand into the debate about vouchers. We do not need vouchers to support public education. We do not need vouchers to support public schools. We do not need vouchers to support students with disabilities. What we need to support students with disabilities is legislation. If you're truly interested in helping students with disabilities and you're truly worried about spending the taxpayer dollars, then we need to call Congress, because back in 1975, the IDEA was established and Congress ensured through their laws that they would fund special education at 40% of the extra costs imposed on states. 40%, that's not even half. To date, since 1975, when this was established, if we think back on it, how many years do you think that they have actually fully funded special education at 40% for the states? Yeah, the answer is zero. Zero. At no time in the last 45 years has Congress actually met their obligation to America's students with disabilities by providing the funding that is necessary in order to provide them with the education. The reason is it's on the discretionary budget. Congress holds the purse strings for this country, and were they to place special education and the needs of the disabled children throughout this country from the discretionary budget onto the mandatory budget, we would be able to better provide for our students. So rather than suing Texas public schools, rather than suing schools throughout the country, rather than coming into class action litigation to take money out of public schools, why don't we work together and start putting money back into public schools? Why don't we work on working with Congress and convincing our congressmen that we care about our children with disabilities in this country and that we need to fully fund special education? 40% is what they should be funding it at. Funding it currently is between 14 to 17%, which is a far cry from what they promised the American people in 1975. Additionally, we need to petition Congress to reauthorize the IDEA. It has not been reauthorized in years, and in light of this pandemic, in light of the new things that are coming about with technologies, in light of all the changing events going on in the world, the IDEA needs to be reauthorized, and it needs to be done so in a smart manner that looks out for children throughout the country. Our students with disabilities are going into an ever-changing world. We cannot sit back and do the things that we did in the 90s and expect them to make sense in 2020 or 2021 or 2025. It is time for us to look at the IDEA, remove the archaic provisions, update them so that they meet the needs of children throughout the country, and get this fully funded. The conversation should be about funding special education. The conversation should be about the quality of work our public schools are doing to provide for children throughout this country. It should not be an attack on public schools, and it should not be used as an effort to try and reintroduce a conversation about vouchers, which generally are not applying to special education students in the first place. We are going to work through this with our clients, and we are going to ensure that they receive the most effective and zealous advocacy in their fight for public education. We represent public schools, and we fight for the needs of children with disabilities. My name is Geneva Jones Taylor, and I thank you for joining me.